At the moment there is stay order of reason, I said नहीं, हम छुट्टी पे जाते हैं, हम कॉट ही नहीं लगाते हैं. What will you do? Move a reference against me? That's about all. You can't compel me under any law to do that. So.
And when these rules were made, if I draw your attention to Order 11, Order 11 को जरा देखिए.
अगर हम बहुत ही pedantic approach ले लें,
Order 11 मान लो.
ये pedantic approach ले लें, ये किसने बनाए? किसने बनाए?
Supreme Court ने.
कब?
1980.
Supreme Court क्या होती है? नहीं, hang on. If you go into that approach, Supreme Court क्या होती है? बताइए.
All the Chief Justice and the judges
sitting at home. No way. No, but if you're going to go that route, then you can even say these are what is they say Supreme Court can make, not administrative meeting of the judges of the Supreme Court. Where does the Constitution provide for an administrative meeting of the judges of the court? So we don't want to just destroy the entire system of governance. So did we sit in a court of law? Did we pass a judgment? How did these rules get enacted? Did people have a say in the matter? Or 10, 15, 17 people, then all gentlemen got together in a closed room and say, here, where is the concept of an administrative thing? That administrative concept itself is created by the rules. So surely it cannot supplant the Constitution itself. It says the Supreme Court. It's very clear. Now, I'm not really understanding. I am only concerned with one and only one thing. What have we taken away from Khwaja Sahab, his client, or any citizen of Pakistan? What have we taken away? What have you taken away? If you've taken away something, we will strike it down. I mean, I don't know why we are having this academic discussion. I really don't understand the point.
My Lord, if I may.
Ji.
Now, there is this provision under this law, and Section 7, for example, application for fixation of urgent matters. Do we not know that there are people who died in prisons, condemned to death before their appeals came up for hearing?
This is our domestic affair.
No. With great respect, my lord, it is not.
It is.
Absolutely not, my lord. With great respect, this is the right of the citizen. Litigants ka right hai.
From the executive domestic affair.
My lord, with great respect, it is not.
Resolve this.
It can't possibly.
Learned Attorney General, what if the Chief Justice refuses to call a meeting of the full court and refuses the full court to amend the rules? Should the Parliament not intervene in the interest of the litigants? That is exactly what happened.
And here, if my lords may kindly turn to Order 11 of the Supreme Court rules. Order 11 of the Supreme Court rules. I'm just going to take this point forward. Order 11 of the Supreme Court rules. It begins by saying, save as otherwise provided by law. The full court, going by, let's say,
एक मैं आपको इसमें तसादुम दिखा दूं अब मौजूदा रूल्स में जो आइन से तसादुम रखती है, ठीक है. अपील इज अ राइट. Civil petition for leave to appeal is not a right. For an appeal, the rules provide 30 days, which is a right. For a civil petition for leave to appeal, you get lots of time, 60 days. I would say it violates the very concept of the Constitution. Maybe it's a mistake, but the other question would be, can these rules be challenged? I think they can be challenged. If they had a supra-constitutional effect, they can't be challenged. Suppose suppose tomorrow I refuse to fix any bench. What will compel me? At the moment there is stay order of reason, I said नहीं, हम छुट्टी पे जाते हैं, हम कॉट ही नहीं लगाते हैं. What will you do? Move a reference against me? That's about all. You can't compel me under any law to do that. So the object is, there has been a problem, there has been successive addition of cases. We are completely closing our eyes to it. हम 2019 में full court meeting हुई थी, वो भी हम नहीं कॉल कर सकते हैं, वो भी इख्तियार चीफ जस्टिस का है. 2019 से 4 साल गुजर गए हैं, क्यों नहीं मीटिंग कॉल हो रही है? 2019 से उस जमाने में 40,000 केसेस थे, अब उसमें ऐड हो गए 27,000. हमारी मर्जी, हमारा डोमेस्टिक अफेयर है? नहीं, हमारा डोमेस्टिक अफेयर है, पर हम तनख्वाह नहीं लें स्टेट से. हम टैक्स पेयर हमें पैसे देता है, हमें एक काम के लिए पैसे देता है, केस का फैसला करो, ये हमारा काम है और कोई काम नहीं है, बाकी सारे हमारे पेरिफेरल काम है. तो ये आप इतने आप उस मेन पॉइंट पे आप नहीं रह रहे हैं, आप भी खिसक रहे हैं उधर, वो भी मेन पॉइंट पे नहीं आ रहे हैं.
My lord, I just
जो आप पढ़ रहे थे कॉन्स्टिट्यूशन ऑफ बेंचेस का,
जी,
इसको पढ़े ना, ये सेव एज अदरवाइज प्रोवाइडेड बाय लॉ.
जी.
तब तो कोई लॉ था नहीं.
जी, उस वक्त नहीं था. recognition थी कि law provide कर सकता है कोई, उस वक्त law नहीं था.
अब ये लॉ, क्या ये आपके ख्याल में ये जो 1980 के रूल्स हैं, ये लॉ है?
My lord, these are
नहीं, आपसे सिंपल, आर द 1980 रूल्स लॉ, कम विद इन द पर्व्यू ऑफ लॉ?
191 की definition क्या आप
No,
notice
Article
कीजिए?
191.
No, sir.
नो,
But these are the rules.
These are the rules. The
But
language
it is-
says subject to the and the law, the
See,
Supreme
but
Court
what
will
is
make rules.
what is the purpose of mentioning save as otherwise provided by law?
Yes, this is the recognition of what Article 191 provided. Now, at that time, there was no statute or an act of parliament which provided for anything, but the
We
full
need to say
court of
that
this
now
court left it
law-
open.
Now the law has been
Knowing,
promulgated, and this covers under this provision.
yes, not just this provision, it is covered under 191. This only recognizes what 191 already.
Mr. Attorney General, then you are excluding all those laws which are made under the delegated powers. You are excluding all those laws which are made under the delegation of the power by the government or the parliament. Delegated legislation
In what context, my lord?
in the context of definition of law. There are two primary law and the delegated law. And delegated law includes the rules.
No, we are looking at.
The Supreme Court rules are not law.
We are only looking at the language of 191. We are looking at the language of 199, and we are trying to understand what is the term or what is the scope of term law as provided under 191 is.
Yes.
Now, I had taken your lordship through how this provision or the pari materia provision had historically progressed, where in addition to parliament there was a executive as well. That role was taken away, that role was eliminated, but the role of parliament remained. And, my lords, Article 67, which provides for the regulation of the rules of procedure of the houses, there is no such
You have not
language.
You have not argued on Article 142
मैं
because this
उसकी
is
तरफ
the
हूँ।
distribution of legislative power.
Yes.
And Majlis-e-Shura Parliament shall have exclusive powers to make laws
With respect
with
to
respect to any matter in the federal legislative list.
Yes.
And if we go through Article 50, the legislative list with item 57, it is also related to
58.
58.